The morning the retired judge began building his wall, Silas Prevost was standing on his own dock with a cup of coffee, watching a mason lay the first course of brick 3 feet inside a property line that had not moved since 1936. And he knew, the way he knew a forged signature from across a desk, that the trouble would not be the brick. It would be the paper that came after it. He was right. The brick was just the brick. The paper would take 8 months and nearly take his house. Silas was 61, 6 months a widower, 4 months back in his mother's old Creole cottage out on the Tensaw Delta, where the heat sat on the water like a hand, and the Spanish moss never moved unless a storm was coming. He had spent 30 years as a forensic document examiner for the Alabama Attorney General. 3 decades reading ink and pressure, and the small, panicked tremor of a hand signing a name that wasn't its own. He had retired to fix a boat and be left alone. He had not planned on the Honorable Hal Gannister. Gannister had moved into the next cottage that spring, 64 years old and freshly retired from 26 years on the county bench, and he carried his courtroom out the door with him the way some men carry a smell. He stood at the edge of the masonry in pressed khakis, watching his wall go up over Silas's salt grass. "Morning." Silas kept his voice level. "Your line's running wide. There's a core benchmark cut in the old dike that puts the boundary about 3 feet back of your string." Gannister smiled the way a man smiles at a slow clerk. "I drew property lines in this county for 26 years, son. I think I know where mine is." He turned back to the mason. "Keep going." Silas did not argue. He set down his coffee and did the thing 30 years had made automatic. He photographed the wall, the string line, the time, and then he walked to the old federal dike and brushed the mud off the bronze benchmark disc the Corps of Engineers had set into the brick in 1936. Elevation and position, U.S. property mark. Do not disturb. And he photographed that, too. A thing stamped in bronze that had survived 80 years of hurricanes does not move because a judge would prefer it somewhere else. He went up the next day to settle it like a reasonable man, with the original plat from his mother's papers rolled under his arm. Gannister met him on the lawn and produced, instead of an argument, a fresh, certified copy of the county land record. And on it, the boundary already ran exactly where his wall stood. "Pulled it myself, last week," Gannister said pleasantly. "You're welcome to read it. The record's the record." Silas read it. And a small alarm he had felt over 1,000 questioned documents went off behind his sternum, quiet and certain. The boundary call had been amended. A correction entry, dated 3 weeks earlier, in ink that sat too crisp on paper that old. Over a notary stamp he would come to know very well. The record said one thing. The bronze in the dike said another. One of them was lying, and bronze does not lie. The county recorder's office, when he went, was no help at all. The clerk, a nervous man named Dewey Sasser, who had worked under Gannister for years, confirmed the amended copy was what the system shows and would not meet his eyes. The sheriff's deputy told him it was a civil boundary matter and added, lowering his voice, that the man on the other side of it was Judge Gannister, as if that settled the part the law hadn't. It nearly did. That was the thing about Gannister that Silas came to understand slowly. His power had never been the gavel. It was that for 40 years, no one had made him finish a sentence he didn't want to finish. People simply stopped pushing. The wall was not really about 3 feet of saltgrass. It was a man who had just lost his courtroom, discovering he could still draw a line and make the world redraw itself to match, and needing, badly, to know that he could. The retaliation came fast and from official-looking directions. A code complaint landed on Silas's boat dock, unpermitted structure over public water. A lien threat followed. A man from the county came to photograph the dock and left without a word. Silas logged each one, the way he logged everything, and kept reading the amended record under a loop at his kitchen table until he was certain. The correction date had been altered, the original call abraded away under the new ink, and the notary seal pressed beside it did not match the genuine article. It was a forgery in a public land record. He just had to prove whose hand. The neighbors gave him the first thread, in the low voices people use for things everyone knows and no one says. Ganister had corrected lines before. A fence here, a dock there, always against someone who couldn't fight back. A shrimper, a widow, a family whose English came slow. Nobody had ever taken a judge to court over a yard of marsh. The notary seal led him to Lenora Baptiste. She was 70, black, a notary public, and the keeper of the parish's old record books for longer than the county had bothered to digitize them. And when Silas laid the amended copy in front of her and pointed to the stamp, she went very still and then very angry in a way that was almost quiet. "That's my seal," she said. "That is not my hand. I never notarized that correction. I'd remember signing away a man's marsh to Hal Ganister." She set her reading glasses down. "He's used my name before. I always wondered. Now I'm done wondering." Under ultraviolet at her kitchen table, the forgery gave itself up the way they always did to Silas. The ghost of an abraded date, a second ink, a seal impression a half-millimeter off the register of Lenora's genuine one. He matched the wall, separately, to the thing that could not be edited. He overlaid a photograph from Hurricane Frederick in 1979, where the flood line marked the old boundary exactly, and tied it to the 1936 benchmark in the dike. The bronze and the floodwater agreed with each other, and with the original plat. They all disagreed with Hal Ganister. Kenny Chan brought the third piece and a grievance of his own. He was 34, a Vietnamese-American shrimper whose family had worked the bayou for 2 generations, and he flew a drone with survey-grade GPS because he mapped his own oyster leases. He tied the wall to the federal benchmark to the centimeter, 3 feet and 4 inches over the true line. And then he said, flatly, "He did my uncle the same way, 19 years ago. Moved our dock line, told us the record said so. We didn't have the English to fight a judge." He looked at the wall. "I have the English now." Tamsin Rowe drove down from Montgomery, a lawyer who worked government ethics and public records cases the way some people chase fires. Read the whole file in one sitting and did not reach for her coffee. "Understand what you have, because it's bigger than your marsh," she said. "Moving a fence is a tort. Altering a public land record and forging a notary's seal to do it is a felony. And a judge doing it under color of his office is the kind of thing that ends careers and pensions. We file 3 ways at once. Quiet title to put your line back, a complaint to the Judicial Inquiry Commission, and a criminal referral, but not to the local DA who tried his first cases in front of this man. We go to the state attorney general and ask for a special prosecutor, and we ask every judge in this circuit to recuse because not one of them can be the one to hear it." She finally looked up. "And we do it loud, because the only thing men like this have ever been afraid of is the part where someone refuses to stop talking." Discovery broke the case open into something none of them had braced for. The subpoena duces tecum to the recorder's office pulled the amendment logs going back 2 decades, and the pattern stood up out of the data like a fence line at low tide. Ganister had corrected boundary calls dozens of times across 30 years, always small, always against people who couldn't push back. And in 11 of those cases, the parcels he had quietly enlarged were bought within a year, cheap, through a holding company called Tensaw Heritage LLC, whose registered agent, the filing showed in plain black type, was Ganister's brother-in-law. It was not a judge being arrogant about a yard of grass. It was 30 years of a man using the record itself as a private instrument, because he was the one who certified what was true, and turning a profit on the difference. Then Silas pulled one amendment from 1991 and stopped, and sat for a long time in the heat, with the loop in his hand. The parcel was on the East Bayou. The name on the abraded original was Thibodeau, his late wife's family. Ganister had moved that line too, before Silas had ever met her, and her people had lost a half-acre of landing they'd always believed they'd simply mismeasured. Silas had come back to the Delta to be near what was left of her. He had not known he'd come back to a record she was still buried inside of. He told no one that part. Not yet. He just added it to the board. Ganister did not break, and he did not retreat. That was the part that surprised the people who expected a guilty man to crumble. He reached into his old connections instead. A fabricated complaint appeared against Silas, threatening a judicial officer, built from a clipped sentence at the lawn confrontation. Pressure landed on Dewey Sasser to stop talking. The county suddenly wanted to inspect Kenny's boat for 3 different licenses at once, and when Silas met Ganister one last time at the wall, in the white afternoon heat, the judge did not plead and did not apologize. He drew himself up to the full height of a man who had never once been contradicted to his face, and said, "You're a clerk who reads other men's mistakes for a living. I fixed the ignorance in this county for 26 years. You think a marsh rat with a magnifying glass gets to grade my work?" He was not afraid yet. He was insulted. He had spent his whole life being right by definition, and the idea that bronze outranked him had not finished arriving. The court was slower than the marsh. The special prosecutor took weeks to seat. The local judges recused one after another, until one was brought in from 2 counties over, and the amended record stayed of record while the motions ground forward, the wall still standing over Silas's grass, like a verdict no one had gotten around to appealing. But the filings did their work. The visiting judge entered a preliminary injunction freezing all further construction and barring any new corrections to the disputed parcels, and put a lis pendens on the line. Then discovery turned to depositions, and the floor under Hal Ganister gave way 1 plank at a time. Dewey Sasser went first, and not from greed. Under oath, sweating, he admitted he had entered the corrections at the judge's direction for years, not for money, but because Ganister had held his small county job over his head like a man dangling keys, and Dewey had a daughter in college and no spine left after 20 years of being told what the record would say today. When Tamsin asked him who had instructed the 1991 Thibodeau Amendment, he looked at the table and said the judge's name, and the court reporter typed it, and something in the room shifted for good. Ganister's own deposition sank him, because he would not do the one thing that might have saved him. He would not say he couldn't recall. Asked whether he had directed the corrections, he said he had harmonized sloppy records kept by people who couldn't read a meets and bounds description if it bit them. Asked about Lenora's seal, he said a notarization was a formality, and the substance was correct regardless. Asked about Tensaw Heritage LLC, he said his family's investments were none of a document clerk's concern. He argued, he lectured, he defended every single entry as a public service, and every word went onto the record under oath. And Tamsin let him talk. Because a man explaining why his forgeries were correct is a man confessing in a language he mistakes for a defense. The hearing was the thing Silas had built his whole quiet life toward without knowing it. He set the amended record under the courtroom document camera and walked the visiting judge through the forgery the way he had walked juries through 100 others. The abraded original call, surfacing under raking light. The second ink. Lenora's genuine seal beside the forged impression. The half-millimeter offset blown up 4 feet wide on the screen, where anyone could see the lie. Lenora took the stand and said, in 11 words, that the signature was not hers and never had been. Kenny put the drone data up, 3 feet, 4 inches, tied to the federal mark. And then the court did the thing Silas had quietly asked for, the thing no amount of Ganister's certified paper could survive. It recessed, and everyone drove out to the old dike, and a court-appointed surveyor knelt in the mud and the gnats and laid his instrument on the bronze benchmark the Corps had set in 1936, the one that had ridden out Frederick and Camille and every storm since, and read the true line into the record in front of the man who had spent 30 years certifying it was somewhere else. The brick wall stood 3 feet and 4 inches inside it. The bronze did not care who Ganister had been. That was the whole point of bronze. The court quieted title along the true line, declared the amended record a forgery void from its making, and the special prosecutor folded the tampering, the forged notarization, and the 11 Tensaw heritage purchases into a single indictment with the 30-year pattern attached. Because once you can prove one altered call, the dozens behind it stop looking like clerical error and start looking like exactly what they were. Ganister's arraignment came that winter. He was not let out in irons, men like him rarely are, but the emeritus status that had let him pull a certified copy on a whim was stripped by the Judicial Inquiry Commission. His pension protections dissolved into its findings, and the LLC purchases became their own colder problem. 11 counts of profiting, by deed, off land he had moved with a pen. The special prosecutor, mindful of his age and the years a trial would burn, offered a resolution that returned every dollar and kept him off a long sentence, and Silas did not fight it, because he had spent 30 years learning that the goal was never to break a man. It was to make the record tell the truth again. What Silas did fight for was everyone else. He made the review reach every line Ganister had ever corrected. Kenny's uncle got his dock landing back on paper for the first time in 19 years. 3 other families along the bayou got letters that began with the word restored. And the 1991 Thibodeau half-acre, his wife's family's landing, went back into the record in her family's name, which Silas asked the clerk to read aloud when it was entered, and then stood very still while it was, and said nothing, because some corrections you let the paper make for you. The county did the unglamorous, necessary things afterward. An independent audit of 2 decades of amendments. A new rule that no boundary correction could be recorded without a tie to a physical federal monument, bronze over ink, permanently. Protection for notaries against the theft of their seals. Lenora Baptiste's old parish books, the ones she'd kept by hand for 40 years, were scanned into the county system as the master reference, which she found funny, she said, given how long she'd been told they were just an old woman's hobby. Kenny got the contract to map the Delta's boundaries by drone and complained that the paperwork alone would outlast the bayou. Tamsin took 3 more public corruption cases off the ruling. Dewey Sasser kept his job, barely, under new supervision, and started, people noticed, finishing his sentences again. Hal Ganister never apologized. But the Ethics Commission, in its public session, required him to read aloud into the record the list of names whose land he had moved. 30 years of them, family by family, in the flat fluorescent room where no one stood when he entered. And he read them, because for the first time in his life, there was no version of the record that would read them for him. Then he sold the cottage and left the Delta, and the new owners, a young couple with a baby and no opinions about marsh rats, took down the last of the wall and used the brick to build a barbecue. On an evening that fall, with the tide coming up gold across the grass and the moss finally stirring in a breeze off the Gulf, Silas Prevost walked out to the old federal dike with Lenora and Kenny and a small can of paint. He didn't make a speech, and he didn't bolt up a plaque. He knelt in the mud where the wall used to throw its shadow, brushed 85 years of grime off the bronze benchmark, and carefully repainted the worn numbers so they'd read clear from a boat out on the water. "There," he said, standing back, knees cracking. "Frederick couldn't move it. Camille couldn't move it." He capped the paint. "Turns out a judge couldn't either. He just had better penmanship than a hurricane." Lenora laughed, low and satisfied, the sound carrying out over the water where the shrimp boats were coming in. Kenny was already flying the drone one more time, for the record, the way Silas had taught him. Because the marsh forgets nothing if somebody keeps the measurements, and somebody always would now. They stood there a while in the last of the light, 3 people in a bronze disc that had outlasted every storm and one judge. And then they went in out of the gnats, and the tide came the rest of the way up, and found the line exactly where it had always been. Here's what unsettles me about this one. Judge Gannister never lost an argument in 26 years. Not because he was right, but because no one ever made him finish a sentence. His real power wasn't the gavel. It was a lifetime of people simply stopping pushing. And he genuinely believed that meant he could move a property line by editing the record, because for 40 years the record was whatever he certified it to be. What beat him wasn't a louder voice. It was bronze. Silas understood the one thing power can't touch. A core benchmark cut into a dike in 1936 doesn't care who you are. You can forge a notary's seal, abrade a date, certify a lie, but you cannot edit a physical federal monument that outlived 3 hurricanes. Paper bends to the powerful. Bronze doesn't. And notice the legal hinge. This stopped being a fence dispute the second he altered a public record under color of his office. That's not a tort, it's a felony. And a pattern of it across 30 years is what pulls in a special prosecutor instead of a local judge who tried his first cases in that man's courtroom. The quiet lesson is that the oldest honest mark usually outranks the newest confident one. So ask yourself, how much of what you know about a boundary, a deadline, a deed, is real, and how much is just someone's certainty that you'll never check? Silas checked. The tide came up and found the line exactly where it had always been.